5 years since the Me Too movement took off comes a change that will give women more protections in the workplace. And in what's become a rarity in Washington, it has bipartisan backing. Amanda Vinicky joins us now with more on the congressional measure President Joe Biden is expected to sign into law. Amanda.
Harris, it is illegal to subject an employee to sexual assault or harassment, but what happens when it does occur? For an estimated 60 million workers in the United States, the answer has been forced arbitration. Michael Leroy with the University of Illinois School of Labor and Employment Relations says that arbitration has been around since King Solomon suggested splitting a baby, and he says that it is a good system when arbitration is voluntary. But he says since the 90s, it has become increasingly common for workplaces to make it mandatory.
What that means is you're giving up your constitutional right to go to a court first. Second, it means you're going to play by the employer's rules for arbitration. Some of the rules are even-handed, some of the rules are egregiously unfair. But even with the even-handed rules, you don't get the benefit of a jury.
Doesn't sound like a great deal for employees, but Deborah Anthony with the University of Illinois Springfield says that workers aren't given a chance but to agree to going through that process, hence forced arbitration.
Presented with a contract that you have to sign, it's often in the fine print, and it's take it or leave it. So if you're not happy with it, you don't take the job. And so you don't have equal bargaining power on whether you agree to that or not. And you have to accept it as a blanket matter for any potential situation that comes up that hasn't happened yet, that you're not aware of.
Leroy says that businesses often design the arbitration process to go in their favor. For example, a complainant might not be allowed to have an attorney by their side, and if they lose, they could have to pay for the whole process.
For employers, there's a great advantage. First of all, it reduces your liability greatly. So even in cases where there is a finding of sexual harassment and misconduct, the payout is a lot less typically. In one research project I did, I found that women actually won more frequently in arbitration than in court. However, their payouts were much smaller.
Another benefit to companies, arbitration is private and often comes with a confidentiality clause.
Arbitration is secretive and private, as opposed to trials which are public. So in sexual assault and harassment cases, that lack of transparency tends to benefit the alleged wrongdoers rather than the victims.
So meaning that bad actors are shielded from the shaming and embarrassment that may come along with the judgment. And it is also hard to collect information on repeat offenders. Now, all these biases came to light during the Me Too movement, including as former Fox News anchor Gretchen Carlson went public with allegations against now deceased Fox executive Roger Ailes. Carlson was in Washington this week to celebrate the measure's passage in Congress.
Today, I'm here on behalf of the millions of American workers who have been silenced for doing nothing wrong. Workers who simply wanted to go to their jobs every day and work in a safe environment. Workers who had the courage to come forward to say something was wrong and in return got shunted into a secret chamber most of them never heard from ever again.
Director of the Illinois Coalition Against Sexual Assault says that this is a significant change. She says that victims are deserving of protections, including when they're assaulted or harassed at work.
This is your livelihood. This is the way you make your living. And so having limitations as to what you can do if you've been sexually harassed or assaulted in your workplace, knowing that your career could be affected, knowing that your specific position, not only your specific position right now, but moving forward could be affected.
Now, this law will apply retroactively, and victims will still be able to choose arbitration. Experts that I talked to say that many may well choose to do so for their own good reasons. For example, they want to protect their privacy, but it will be a choice, not a mandate.
It's going to help companies get on the right side of history, that's for sure. But it will also stop the bad behavior, because now the bad actors will know that women's voices will be heard when they speak up.
Still, scholar Deborah Anthony points out that forced arbitration is still permitted for other workplace claims, such as those of racial or religious discrimination, or maybe a family leave dispute. And when it comes to protecting sexual assault survivors, Ward's group says that Congress needs to reauthorize the Violence Against Women Act that has stalled. Also, she's calling for passage of legislation that gives survivors more options in the opportunity to pursue criminal and civil legal penalties.
Really for survivors' rights to be acknowledged and for offenders to be held accountable for their behavior. We want to see, sentencing that's consistent with charges that are brought forward. We want to see charges that are brought forward that are consistent with the actions that have happened. We want to see fewer plea agreements. We really want to see survivors have access to justice that should be available to them in the system. And we want to make sure that our laws uphold that.
She says that there's room for improvement on both the state and the federal level. And one area that she keyed in on is protections for campus sexual assault, saying that those who are aged 18 to 24 are particularly vulnerable. By the way, rape crisis centers that are part of ICASA's network are available to provide support to victims 24 hours a day, 365 days a year. Back to you.
All right, Amanda, thanks very much. And